Hi, Mac. Hi, Tim. Hey, Ed.
Hello.
And Liz is on too.
Hey, Lydia.
Hey. Scout's honor, Ed. Who was here first? You or Liz?
I think Liz was.
Okay.
Yeah.
Okay. I don't expect, we did check with a lot of the housing advocates, everyone. Most of them are focused, obviously, at the State House right now. So it looks like it'll just probably be Mac and Tim. Mac from GBLS and Tim from DND. And I will just give it maybe 2 more minutes for my colleagues to get on, and then we'll just get to work. Okay?
Sounds good.
Text everybody really quick.
Good morning, Councillor Edwards.
Hi, Councilor Braden.
How's it going?
Good, good.
You're busy these days.
It's particularly painful, but I think the goal, because we're trying to do, I think, 4 or 5 ordinances.
Yeah.
Help them out of government ops. I'm trying to move good ideas along.
Yeah.
Okay, well, you know what, we're just gonna go ahead and get started with the set of us. We'll get a lot done. Let me do the formalities. Good morning, everyone. I'm City Councilor Lydia Edwards, Chair of the Housing and Community Development Committee. It is Thursday, October 15th, 2020. We're here today for a virtual working session on docket 0389, order for a hearing regarding condominium conversion protections in the city of Boston. I'm the sponsor of this docket and was referred to the committee on February 12th, 2020. In accordance with Governor Baker's executive order modifying open meeting laws, we are balancing both the needs of the public safety of this pandemic, but also allowing us to continue to do our work. So we're doing this on Zoom, and the public may watch this on Comcast 8, RCN 82, Verizon 1964. They may also watch a live stream at www.boston.gov/city-council-tv. If you have any written comments, you may be sent to the committee at ccc.housing@boston.gov or to Juan Lopez, which is JUAN.LOPEZ@boston.gov, and they will be made part of the record. We're here today to design the next steps in crafting a stronger condo conversion law. Some slight background: this law needed to be renewed in 2019. We extended it for 1 year, as it was presently written at that time, to make sure that we had the time and the energy and the feedback from everybody to strengthen the law. And we will be renewing this law, very likely for another 5-year term this year. So we just want to make sure we got all of the feedback and updates that we could into it. So I've been joined by my colleagues, Councilors Liz Braden and Councilor Ed Flynn. I think that's it for right now. We also have been joined, we'll be hearing testimony and suggestions from Mac McCrate from Greater Boston Legal Services and Tim Davis from DND. Do I have everybody who's on? Okie dokie. So why don't we just get right to it? Tim or Mac, did you want to walk through the presentation and suggestions? All right.
I will.
I can do that. Yes. Thank you. Just for the record, I'm Tim Davis. I'm the Deputy Director for Policy Development and Research at the Department of Neighborhood Development. Sheila Dillon, the Chief and Director of Housing in the department, is, however, is at our important Housing Boston 2030 Advisory Task Force meeting this morning. So she sends her regards. I will be sharing my screen. Let's see. Okay. You should be seeing the conversion ordinance summary. Is that correct?
Yes, we see that.
Yes.
Okay. So I'm just going to step through this, and I think that and hopefully kind of go through all of it, and then we can go back to specific sections if that's helpful. Properties covered 4 or more units, that is what we are enabled to do. As we have discussed previously, we cannot do properties that are smaller than 4 units under our current enabling. Households eligible for additional notification relocation benefit. This is both how it has been existing and what we are proposing. Someone who is disabled, who is elderly, age 62 plus, or is low or moderate income, meaning less than 80% of area median income. Those are who are eligible for additional notification or relocation benefits. The notification periods, currently we're proposing that the general requirement is 1 year. For eligible households, it is 5 years. That is the same as in the existing ordinance, but is also, as you will see here, we have really leaned into, with Mac's assistance, looking at the new Somerville Ordinance, which we think is quite good. We have a few modifications to that based on what we think might be either A, improvements, or B, are looking at the different kind of enabling that we have that may be different from Somerville. And in the so if I mention the Somerville Ordinance, sometimes I'll compare what we're proposing with what they're proposed, what they have put in place. So in this case, in the notification periods, Somerville is also doing a general requirement of 1 year and in eligible households of 5 years. What will be new is that for vacant properties, there would still be a 1 year waiting period before they would be allowed to sell any units. That is something that would be new under this revision of the ordinance. A form of notifications to tenants, the Office of Housing Stability would create, specifically spelling out conversion processing, the conversion process and tenant rights, and it would be provided in multiple languages. Rent increases during the conversion period. This is as we have now, and I think it's similar to what Somerville has. I'm not clear on that, but it's limited to 10% or CPI annually, whichever is less, for the remainder of the notice period. So for general tenants, that might be 1 year. For eligible tenants, that might be 5 years is that notice period. The relocation benefits, the general requirement has been and is also the same for Somerville, is currently $6,000, and for eligible tenant is $10,000. In our last working session, the notion was put forward that maybe we should increase that to $10,000 or $15,000 for eligible tenants. I think we should come back to that and make some decisions there. And just to kind of clarify, in our last working session, Chief Dillon said something referring to what does it actually look like in the market for things like first month, last month, and security deposit. And based on 2-bedroom average rents, first, last, and security would be $7,500, just as kind of a benchmark for us to look at as well. This change would introduce a right to purchase. The tenant has 90 days to sign a P&S. That's also, we can discuss those days, but 90 is the current, and I believe that's what Somerville has. The city has the right to purchase a tenant's unit or can assign it to a nonprofit as income restricted. The city actually wouldn't buy any units directly. They would always be assigning that right to another agency. Where there is this came up last time in terms of what happens about if there's a reduction in units or if there's a situation where the building is actually torn down, where there is a reduction in the total units, or the building is demolished and replaced by a condo building, the tenant has the right to purchase a unit in the building, including, if eligible, any income restricted units. So for example, if it's a 8-unit building and they decide to combine some units and it goes to 6 units and their unit is no longer available, they would have the right to buy one of the other units. In that case, they would still have to be able to afford a market price, but at least they would have that right. If, for example, in a situation where the building was going to be torn down, like a 6-unit was being torn down and a 20-unit condo was being built, they would be eligible to buy a unit in that new building. And if they were also income and asset eligible, could purchase one of the IDP units. The enforcement currently, tenant has the full responsibility of understanding their rights and going to housing court to secure benefits. Matt can correct me if I'm incorrect in that. Proposed the condominium conversion permitting system with required tenant notifications and fines from the compliance. And to kind of, in the next page, I'll really go through what those steps look like, at least as they're proposed. But to give you the high level, the permitting process would occur at the Inspectional Services Department. It would be housed in with the same group of people who are doing the short-term rentals because they have kind of built up their capacity. And we think that I've had discussions with ISD already that they would be capable of doing this. Currently, we have about 20 to 30 conversions of buildings with 4 more units per year. We think that that is a reasonable capacity for them to address it. And also, given the process we're putting in place, we think that some landlords may choose not to go forward. So that may lower the number of such properties anyway. And so in reporting, ISD would be responsible for submitting an annual report on their activities annually. So to kind of go through the permitting and notification process, I only just have a few more minutes and then we can dig into it. Step 1, the landlord would notify tenants with an ISD OHS approved forms that they will be seeking a conversion permit. Step 2, the landlord or converter applies to the Inspectional Services Department for what we're calling a conditional conversion permit. In our previous meeting, there was some discussion about using the term removal or what the difficulty might be or what that relationship was to old rent control law. We think this more adequately represents what the process is. And thank you, Matt, for kind of coming up with this idea of doing a conditional permit. So before I go into the specific steps, the developer goes to ISD for a conditional permit, which starts the process. Basically, ISD is saying, you've done what you're supposed to do so far. We've done a look back and we haven't kicked out your tenants improperly. We're going to allow you to proceed. And then they come back for a conversion permit just before they actually sell the units, which basically says, which is a confirmation that says, you did what you were supposed to do. We're now going to allow you to sell the units. So that's the conditional, is like start the process and the notification period, and the conversion permit is attained when they actually go to sell the units. So the landlord would go to ISD. ISD provides the landlord with a full understanding of both their and tenants' rights and responsibilities. Owners must provide proof tenants were notified and evidence of who is living in the building currently, and information on any residents who lived in the project over the previous 12 months. If the applicant has purchased an empty building or a partially empty building, the applicant is still responsible for providing information on the previous residents. Also, at this point, there would be a hearing. There would be an opportunity for a hearing. For example, if there's any question about what the owner did in terms of previous tenants, there could be a hearing process for that. Step 3, the Office of Housing Stability works with tenants to assess eligibility for enhanced notification or benefits. So by doing that at this point, that will help ISD understand whether they're supposed to be giving out just 1 year notifications or a combination of 1 year and 5 year. At step 4, ISD would release the conditional conversion permit. Tenants will have the ability throughout the notification period to report any concerns and notify the city if they move, sign purchase and sales agreement for the unit, receive relocation benefits, or face eviction proceedings. So in other words, basically they'll have someone at the Office of Housing Stability they can contact at any time. Step 5, the landlord seeks a conversion permit. So they're preparing to sell the units. ISD and OHS determine the owner met requirements of ordinance, and ISD releases the permit. Step 6, unit sales and project closeout. Sales of units proceed. ISD and OHS confirm the final outcome, including any unit sales to tenants at conversion. So basically there would be, before they were given the conversion permit, there might be a purchase and sales agreement with the tenant, but it would actually close after they actually start selling. It was closed when they're selling the other units as well. So those are the steps in the process. I'm willing to go back to any section that people are interested in. And thank you for your time and patience in listening through the whole proposal.
Thank you. Mac, are you able to hear me?
I am.
Okay.
So what I was going to add on this is it's called a conversion permit rather than a removal permit, partly because it might not always be that the conversion of a property is actually going to lead to displacement of the resident. So it may very well be that an owner, as has happened in the past, may just be interested in getting marketing condos as units become vacant, but actually doesn't have any immediate interest in pushing people out that are in the occupied units. So, but those tenants still would have the right, if there's going to be a master deed filed, to be able to purchase their unit if they're wanting to become an owner of that unit. And that part is part of the pre-existing scheme, that when there's actually a conversion, tenants do have the right to purchase whether or not they're going to be displaced. We recognize that might happen. There may even be times when condo conversion may happen as part of some affordable housing deal. I know we haven't hit that yet, but I know that there have been some discussions about redevelopment that may include using condo as a mechanism, for example, to scatter low-income housing tax credit units within a complex. So just want to make that distinction, that it shouldn't always be assumed that because there's a conversion, there's a displacement. And the SJC is really firm on this, that back in the 80s, they came out with a decision that said, you can't always assume that because there's a conversion, there will be a displacement. So you need to sort of separate out the two things a little bit. But this mechanism allows both things to happen.
And I think that's also important to bring up, that this ordinance would also apply to cooperatives. Obviously, in most of the cases where we hope that there is a cooperative created, that they will be to preserve the housing for the existing tenants. So there are situations where a conversion to a co-op is actually something that we're looking for, that we're hoping for.
So I just wanted to, Tim, your memo of a summary, have you, maybe we could keep that up on the screen, because we've just been joined by Councillor Bach and Councillor Mejia. And what I think might make sense is we break down each section and what's proposed to be new. We don't have any specific language with us today. I think today's working session could probably be that we agree to or answer any questions to these changes, which all sound great to me. So so far, I think it's great. And so if we can get language together, then we can get that before my colleagues. We've been joined by Councillor Mejia. We've also been joined by Councillor Bach. We did not have opening statements, Councillor Bach or Mejia. We just got to work. So what I would like to do is check in with anybody who has questions right now for Tim or Mac about what we just saw before we go back over it again to see what the changes are. I have two questions, but Counselor Flynn, Counselor Bach, or excuse Braden, do you have any questions right now about what we just saw?
Thank
No,
you.
go ahead, Councillor Flynn.
Yeah, thank you. Thank you, Councillor Edwards, and I strongly support this proposal, especially providing protection for our seniors, for persons with disabilities, low-income residents. What protections, Councillor Edwards, are we looking at, if any, for immigrants in our communities? Is there any protection, whether it's fair housing or any other protections that might assist immigrants, which, as we all know, are low-income tenants as well? So just wanted to ask that to maybe Tim or yourself, Councillor Edwards.
So in as much as the Enabling Act allows us, well, let me just say this. Our Human Rights Commission laws of the City of Boston already ban discrimination based on national origin. In as much as we would like to take those laws and add in immigration status as a protected class, we would have to do that under that ordinance. In as much as there are any additional protections or classes that we would like to add to this condo conversion, I could turn it over to Mac to see if we can add additional protected classes for eligible notification and relocation benefits, or does the Enabling Act kind of limit us?
What I'd say is, I think the Enabling Act kind of limits you. I agree that anyone who is an immigrant should have the same protections as anyone else if they are an occupant of a unit that's scheduled or slated for conversion. But one of the things I know that came up in our discussion earlier in the summer, which I think Councillor Mejia brought up, and it was a very good point, had to do with limited English proficiency. So I know that in the draft that we've kicked around for internal discussion, and I believe Corporation Council is currently working on, we did include a whole piece about making sure that all those notifications are accessible to persons of limited English proficiency, and that basically DND and ISD would be involved with the formatting of that so that the information would be understandable to everyone.
Yes. Thank you, Beck. Yes, there's certainly notifications we would assure are in a number of languages, probably 10 or 11, depending upon what our language access plan is telling us at that time. And then having our usual ability to talk to people in other languages through the language access line. I think the lower moderate income classification really does kind of get to the core of what most of the people are you were looking to potentially add. I think so. Immigrants as well as Blacks and Latinx people are more likely to be lower moderate income and are therefore covered. Now, I could see an instance whereby, for example, ISD starts the conversion, that the developer starts the application process. They come in, ISD discovers that they actually did kind of illegally evict a group of say, limited English speakers or immigrants earlier in the process. And then we could file a fair housing complaint against them as well. So there would be another option to file a kind of complaint against them for how they worked or didn't work with those tenants previously.
Excellent. I just had, was that all for your questions, Councillor Flynn? I had a...
Yes, Councillor Edwards, I just want to say thank you to you and to the two panelists for their exceptional work on this proposal. I support it 1,000%, and I know it's in good hands with this group that's working on this issue. Thank you, Councillor Edwards.
Thank you, Councillor Flynn. My two questions, and I think one was from the last time, and I think it was actually from Councillor Braden, or one of the other councillors, but also, so the first question is, does this law apply if I take my 2-family and create a 4-unit condo building? Remember? So so that was the first question.
Right.
And then I remember that was, I think it was Counselor Braden. And then the other question I had was about the condo conversion notice or permit, the conditional permit that you just proposed, which is great. I just wanted to make sure that it doesn't seem to be limited by whether you're doing 4 units or not. That it seems, I mean, we could write it such that if you're going to create a condo and convert into a condo, you as a landlord have to come to ISD for whatever size the building. Now, of course, the notice of rights and what goes out to those individuals might be different, but it seems like this is a wonderful way of still getting a touch point for everybody in the city of Boston who might be living in a unit that's going to get converted to a condo. So I'm hopeful that the language is broad enough that for this conditional permit, landlords would still have to tell their tenants, even if they just told them OHS exists, right? And none of these other options are available to you if you're at less than 4 units, but OHS exists if you are concerned about where you're going to live, what you're going to do, so on. GBLS exists, you know what I'm saying? So I'm hopeful that the conditional permit could still be a touch point that, as we're already doing with the HNA, the Housing Notification Act, this is another touch point where landlords have to tell people about their rights. So those are my 2 questions.
So just a thought on both questions. So I think we talked about the two to larger before, and there are problems with the enabling law about that. I could see where an owner could come back and raise a serious issue about that, given the city's limited enabling authority and the fact that it is so hinged on what the existing space is. On the other hand, I know sometimes people say different things about a space. So for example, it might be that the certificate of occupancy said it was a 3, but there are some city records that show that it actually is being rented out as a 6. And I think those ambiguities you could use to say, bring it in. And I've had those cases before for some properties which were illegally converted in South Boston. On the other issue, I think it would be, while I agree with the idea of trying to use ISD's general authority to say to landlords, you need to come here and make sure that everybody knows about their basic rights. The problem is, if we put that in an ordinance that says specifically it's under 527, that makes it again a little bit murky about whether or not we may be going outside enabling law. It may be cleaner to do that as a separate ordinance, which doesn't say it's under 527, doesn't say it's under any of those bells and whistles for the buildings that are smaller, and is similar to that Housing Notification Act in that way. I know we've had to sort of cabin in the Notification Act because, again, without larger enabling authority, there may be problems or issues that could come up. But I agree with the general concept.
So maybe the solution is for the HNA to add in this condition or reference the conditional permit in the act that the city is doing right now that the mayor introduced. Just add in language under that in as much as you're going to convert, you still need to seek the conditional permit and notify your tenants in those cases as well.
Right, or any kind of notification that may involve ISD. So for example, we've seen cases where there's a rehab that happens all around tenants. It essentially amounts to constructive eviction, and people get pushed out that way. And while ISD has some guidance that says that's not supposed to happen, residents don't know that that's not supposed to happen and that they could call ISD about that sort of thing.
And might I suggest, in terms of just a procedural thing, obviously this is a new idea for us. We'd want to look at it. And I think Mac's thoughts here are really sound. I think from a kind of process perspective, because we don't want to discuss a permit process in the notification bill that doesn't exist yet. I think
Right.
what we would do is we would do 2 ordinances at this time. When we did this, we could do a companion ordinance that does the notification. So then that would give us the time to kind of think it through.
Okay,
Yeah.
okay.
So
So,
in other words, not amend the current notification ordinance that we're contemplating now, but doing a companion ordinance at the time we do this ordinance.
got you.
Yeah.
So two under this, 2 under the condo conversion, leave the H&A alone.
Right.
Okay. Okay.
Right. And that's specifically about evictions anyway, so I think that we could keep them separate and it would work.
Got you.
Yeah.
Do we need, we are going to refer, however, to the condo conditional permit in this ordinance, or are you proposing we have to do?
No. The one reason why we don't have a full text view now is because we're not just doing small edits to the existing ordinance. It's
Right.
that we're basically doing a gut rehab, if you want to use a building term.
That's fine.
We're doing a gut rehab of the ordinance,
Right.
and to bring in a lot of the features from the Somerville Ordinance, and then, of course, tweak some of those to be in line with our enabling.
Very well.
Yeah.
Okay, great.
Yeah.
So I can, we've also been joined by Counselor Janey. So I am to the counselors who joined after the presentation. I would be Counselor Mejia, Counselor Bach, Counselor Sabi George, who also joined us before Counselor Janey. What I think might make most sense, because is for Tim to again go through in blocks of the current ordinance and the gut rehab suggestion that he has for it.
Yeah, okay.
Right? Or that sometimes it's not a gut rehab, sometimes it's just a little plaster. And
I know.
But
And
some of it is
sometimes a little paint does what we need. So
Right.
yes.
We've got a lot of hesitancy in my district about gut rehabs, but I'm up for this one. So
So we didn't really have opening remarks. We just got to kind of what the summary of the changes were. So Tim, if you want to go back to sharing the screen, and Mac, I'm assuming you've seen, and GBLS is good with most, or if not all of these changes?
Yeah, we've been working with
Oh, you've done it.
DND
Okay.
and the city on all of this, yes.
Wonderful. So if we'll
Okay.
go back to sharing.
Counselor Edwards, if I may just ask a quick question. Are you asking Tim to review this because some of us have arrived late? That's not necessary. I'm happy to rewatch the video for the missed portions, as it was my bad for being late.
No, and I appreciate that. No, what I'm asking him to do, and this is for everybody, is he summarized what the changes were, but now we want to go section by section and thumbs up, thumbs down, and then keep moving. And I figured that would be helpful for everybody.
Okay.
Okay, here we go again.
Yep.
Summary. Okay.
Yep. So again, properties covered 4 or more units. That's our eligibility question. That's our enabling question. Again, now we've just had a discussion about maybe that there's some kind of at least notification process around condominium conversions for buildings with 3 or fewer units. So that would be an additional ordinance we might look at. The households eligible for additional notification relocation benefit. This is as under the current ordinance. It's also what's in the Somerville Ordinance, and it's what we're proposing here. Is it for those who are disabled, elderly, age 62 plus, or lower moderate income, meaning less than 80% of area median income. And I'll pause after each little section and see if there's any questions.
Just to summarize also, the low to moderate income is not dependent on immigration status, as we also discussed. It's for everybody. And that's how we think we're getting majority of our vulnerable population.
Yes, thank you. Notification periods. The current ordinance and the Somerville Ordinance both have a general requirement of 1 year for most tenants and 5 years for eligible households. Now, one comment on that I'd like to make is that there's been some question about whether we should extend those notification periods. Now, that's certainly something we can look at, but I also believe that with the certification process in place, that additional notification periods may not be that important, because then we're confirming that they're really getting their real notification periods. And vacant properties, this is something that is new, that if there is a vacant property, if ISD determines that in fact those tenants did leave properly rather than were pushed out, the owner would still have to wait 1 year before they could start selling units. This is really to encourage building owners to actually just go ahead and keep their tenants in place through this process rather than pushing them out.
Before you continue, Tim, just for a lot of folks' education, what do we mean by notification periods? This is actually the time that they're given, am I correct, to stay in the unit?
To either stay in the unit and or there would be, if they can leave earlier, but it would be at the tenant's, the tenant would do that voluntarily because the landlord has either found them comparable housing within their neighborhood or within the city in a neighborhood that they're happy with, or they have taken the relocation benefit, but it would be that they would only leave voluntarily. But then after that 1 year, then they could actually ask the tenant to leave, or 5 years in the case of an eligible tenant. Mac, do you want to clarify that any further?
Yeah, no, that's all correct. And the one thing that's a little different is, again, it may be that an owner at the current time doesn't want to displace someone and is merely doing a conversion or attempt to sell some units in the building. If that happens, if they then do want to do a subsequent displacement of somebody who was there at the time of the conversion, then the notification period would start to run for the person then, either 1 year or 5 years.
Okay, thank you.
So just a quick summary again for some folks who may appreciate this. If I am going to convert my building, that's at least 4 units, right? And I have protected someone who's disabled, a person who's elderly over 62, low to moderate income, I have to give them, if they're a general requirement, a 1 year notification period, as in 1 year from now, you will have to leave. These are your rights, so on and so forth. If they're one of the protected class above, they get 5 years, a notification period. And then I believe what's new is the vacant properties.
Correct.
1 year, am I correct? Okay.
That's correct. That's correct.
Just summarizing for just doing that. Sorry, go ahead. Tim.
Right. Form of notification to tenants. Currently, it's all on the tenants' kind of shoulders to understand what their rights and responsibilities are. There's no notification requirements. So I think this is what's really, starts the important new changes, is that the Office of Housing Stability would create specific notification forms, specifically spelling out the conversion process and tenants' rights, and provided in multiple languages. And that would be, and then obviously there would be a way that they could immediately contact the Office of Housing Stability directly. Rent increases. This is actually not a change from the previous practice, limited to 10% or CPI annually, whichever is less for remainder of notice period. Relocation benefit. Now here's one where I think we have a little work to do. The current ordinance and the Somerville Ordinance both have a general requirement of $6,000. Eligible tenants are at $10,000. I did look at average 2-bedroom rents, and if someone was doing first month, last month in security, they would need to have $7,500 on hand. So obviously, I think the administration is comfortable with increasing it, and I wanted to point out that at our last working session, the idea was floated of $10,000 for general and $15,000 for eligible tenants. So I just kind of will open that up for discussion.
Tim, let me just add to that before the council discusses this, because again, really good for us to get your direction about what you'd like on this, is that the council twice previously changed the relocation benefit from the original 1999 ordinance. Again, seeing that the market had changed and it was really necessary to up the benefit to match what was going on.
And the last change was in 2014.
Yeah.
Yeah.
So to my council colleagues, we've heard some changes, the vacant property being part of the notification period, OHS doing some notification, and now the relocation benefit, which I think we really should discuss those three real quick. I think it's just a matter of cost of living increase. That's why the relocation benefit increase makes sense to me, $10,000 and $15,000. Those are just my thoughts, but going in order of arrival, Councillor Braden.
And just a quick question, the vacant properties, if you look into a vacant property and you discover that there are folks who are eligible in tenants in that previous cohort of tenants that have that were in the vacant building, are they eligible for some further benefit, or is it just, does the owner of the property still have to it just has to have a year and that's it?
So that's the reason for the conditional permit system, is that the city could very well say, we are not going to grant you permission to do this conversion because this happened, and figure out what's the best means to remedy that. You know, the owner may come forward with something that's a sufficient mitigation. It also may be something that the current owner wasn't really involved with, but they're still tagged for what happened in the previous 12 months. And so it may be, we've got some other property here, we can place them into at comparable rents. There's money compensation that we need to make for them. Again, we decided not to spell a lot of that out because, again, a lot of this is going to be very case specific. But the idea that you could say, no, we're not going to give permission is a powerful tool.
That's correct. It could say no. Also, we haven't determined what the fines would be, but there would be a fine structure. And similar to our discussion yesterday about the notification law, ISD would probably put something in place similar to that, where there's up to $300 per occurrence, and those occurrences can be many. And also, one thing is that the text that we're drafting also looks at the intent to convert, and it's kind of figuring out what that intent was. And it could be that they came to BPDA for a pre-file meeting and they dropped the word that it's going to be a condo. It could be that they have secured the services of a real estate agent. It could be any number of activities that show us that there was an intent to convert, and that we can basically find them back to that date in terms of whether or not they were doing the proper thing by the tenants.
Thank you. That's my question. Thank you.
Yeah,
Thank you. Councillor Flynn. Again, the three kind of changes: notification from OHS, the vacant property 1 year, and the increase in the relocation benefit. Councillor.
Did you
Councillor
drop
Flynn?
off?
Oh, I'm sorry. Councillor, I already asked my question, or I support all this. So Councillor Mejia. Councillor Mejia. I don't know. She'll join us if she has, she might have a connection issue. Councillor Bach.
Thanks, Madam Chair. I'm also supportive of all these changes. I think it's great, and I really appreciate the work the team's been doing.
Thank you.
Thank you. Councillor Asada George.
Thank you, Madam Chair. I don't have any questions on this section.
Thank you. Councillor Janey.
Hey, thank you so much, Madam Chair. This all looks great. Just a clarifying question on the relocation benefit. Is this on top of first, last, and security if the tenant has submitted first, last, and security?
No, this would
expecting
be
that back, or
this would be the relocation benefit. Oh, you mean if there was a tenant who
so if you're a
paid,
tenant and
Yeah.
your landlord is converting, they've given you the notification, they've done everything, you've already paid first, last, and security. Obviously, your first month's rent is already,
Right.
can't get that back. But assuming that there's a last month deposit and a security deposit, is this on top of that is my question?
Correct. It is. It is. Yes. Thank you for the clarification. I was
Okay.
confused at first.
Yes.
Yes. So anything that they already had with the landlord, they would get back their security deposit. et
They
cetera.
would get that back. And then on top of that, there would be this relocation.
Correct.
Great, great, great. And then just a clarifying question, right under that box is the right to purchase. The tenant has
Yes.
90 days to sign a P&S. And I love that the first right of refusal goes to tenant. That's so important as we're trying to kind of level the playing field in terms of home ownership. The question for me is, when does that 90-day clock start? So does it start at the year notification? Is it at like, when does the 90 days begin?
Mac, do you want to address that?
In the prior system, it started when the notification went out. With the conditional permit system, we'll need to take a look at that. My assumption would be it would be when the conditional permit was granted, since oftentimes you may not be able to actually do a sale until there's a conditional permit in place. So that's my best answer that I can give on that.
Yeah. And I guess go ahead, Tim.
Yeah, I think I'm recalling from the draft text that, and I think the Somerville system is what we're trying to adopt here, is that it can happen at any point during the notification process, but before they actually sell they start selling the units.
Yeah, so I'm just worried that, 3 months may not be a lot of time for a tenant to get it together and make the, sign a P&S. If they have a year, if they're being notified a year out, why would the clock start at that beginning of that year for them to do the purchase?
Yeah, I don't think the proposal is that it starts at
Oh, I
that
thought
point,
that's
but-
what Max, okay.
Right. But I think I'm reading it a little differently, but I think that we should review that. I think.
Yeah, so
I
I'm
agree.
really
We'll review
interested
that.
in figuring out how we can make sure there's ample time. And if there's a whole year of notification, perhaps, that's when, if someone had a year to try to get their deposits together in terms of a down payment or whatever they need to get together, that's a better opportunity. I think that puts the tenant in a stronger position. So anyway, this all looks good. That's it for me in terms of the clarifying questions. I've got
Thank you,
another
Counselor.
meeting at 11, but we'll stay on as long as I can. Thank you, Madam Chair.
Thank you, Counselor.
Thank you. So Councilor Mejia, I had called her before. She's joined us back again. So Councilor Mejia, just we're discussing just the first three changes to the condo conversion ordinance, which include providing notice for vacant units and those who had to leave, those tenants if the unit's already vacant, providing an increase in the relocation benefit based off of Tim's research. A 2-bedroom apartment, if you're trying to get first, last, and security, you need on average $7,500. Our relocation benefit right now is only $6,000 for general folks, and for the protected people and classes, it's $10,000. We're looking to increase that to $10,000 for general and $15,000 relocation benefit for eligible. And then also making sure that we provide multilingual notices from the Office of Housing Stability. We already got you, girl, on the multilingual part. But go ahead. Just want to give you a summary.
Thank you. I'm going to go to all of the hearings that you host, Counselor Edwards. You're the best educator, aside from Bach, too. She's a professor. So I would just like to ask a clarifying question about the notices. I know that we do multilingual, and that's awesome. I'm just curious about, folks who may not know how to read or write. Like, what type of communication efforts can we make there? Just something for us to consider. I always talk about that just because I know what it looks like. And so just want to make sure that we're really thinking about, when I think about language access, it's not just the interpretation and translation. It's really about, are people able to understand effectively what is happening to them? So just something for us to think about what that would
Thank you. Yes. And obviously, I mean, I can talk to our communication staff about what are some of the possibilities. And obviously the first thing that comes to mind is at least keeping it in very accessible language rather than being really legalese, I think is important for any communications that go out as well.
Yeah. And then I really love Counselor Janey's questions about the reality for people to be able to actually purchase a condo, like that, giving people ample time. I'm curious, and I don't know if this has already been discussed or if this is a possibility, but you know how when you pay your rent on time and they do these rent to own situations, is it possible for the folks who want to buy that, at least if your rent is $1,500 a month, that at least a little portion of that you've been paying, a percentage, can go towards your down payment? Is that something that we can consider to help support?
We can consider it. It may be harder to implement than, but we can look at it.
Yeah, I would just mention that a number of the rent-to-own schemes are often not great. Sometimes are predatory. So just need to be very careful about those. The other thing, I just wanted to go back to the Councilor Janey's question earlier, that the time period to exercise the right to purchase may depend on whether or not the owner is actually doing a displacement or is actually just trying to get the master deed to convert, but actually is agreeing to keep the tenant in place, in which case there wouldn't need to be the 1-year notice to displace and the 5-year notice for protected people. And so you may want to distinguish between those two things. That's part of what we actually have in the draft, but these are all good things for us to be thinking about.
Thank you.
Yes. Okay. Okay, that sounds awesome. My last question then is in regards to the displacement situation. And I don't know if this is, sorry. If it's possible, oftentimes when our people get displaced, they end up having to go to Brockton and Stoughton and Randolph. Is it possible to ensure that if we're going to displace people, they don't get displaced out of our city? Can they get displaced to another part of Boston? I don't know if that's a lot to ask, but I know it's probably crazy talk, but I'm just thinking about if I'm trying to prevent displacement, because I know a lot of people who are commuting from Brockton because they still have to work in Boston. It just causes a lot of hardship for families. So, are we considering what that, it's not just a financial support, but how can we keep our people here in the city of Boston?
Right.
That's a great question. What I'd say is some communities that have done condo legislation have shorter extended periods for protected groups, and then they lengthen it if then the owner doesn't get a comparable unit. We had decided a long time, or at least the previous councils had decided a long time ago not to do that, but to instead just go for the extended time period. But there is language in there that talks about the owner's duty in the meantime to be looking for comparable housing. And they talk about comparable housing in terms of rent level, in terms of the same community, all the sorts of things that many people are looking for. And so oftentimes the smarter owners are out there beating the bush because they say, okay, 5 years, that's just a long time. I would prefer not to have this situation go on for that long. So they're out there and trying to identify units that people might have. Again, need to be very careful to make sure that what's comparable is really comparable, that people don't get some kind of offer on rent that looks good, but it's not really as stable as what they've got. But that's something that having the enhanced role for OHS on this will help a lot with. The previous ordinance was a little bit weak on where the city enforcement was. And I think having the beefed up ability to enforce and regulate will help a lot.
May I also add, the increase in the relocation amount will also make Boston a little bit more accessible. right now, as
Yeah.
you know, the rents that Tim looked at were based off of, I'm a 2-bedroom in Boston. Am I correct, Tim?
That's correct.
So giving people more money allows for them to compete more in the Boston market. If I might also suggest, I'm wondering if they have to leave the city of Boston, could we require that there's an increase in the relocation benefit? So it's almost a disincentive for the owner to give them a check and then say, make it work. It's almost like, we want to cap how much we give. So if, for example, as Councilor Mejia just noted, the person is going to Brockton, the relocation benefit would also include a move cost as well, and all these other things. So it's more expensive for them to leave the city of Boston than it is for us to find a place, for the owner to find a place for them to live in Boston.
Yes. Oh my God, I love you. Yes, because that is real thinking right there, right? Because seriously, it's like the social and emotional trauma that we're experiencing. There needs to be some, I think you're right. I think we should make it, I would have to say that I agree with providing additional resources and money to folks who have to leave the city.
We should look at that. I just want to be a little bit careful about privileges and immunities clauses in the Constitution on this one, around where, you know, in any event, there's been past litigation in Boston about that. So we definitely can look at that, and it makes sense in terms of a policy.
So,
Thank you.
okay. So
Councilor Edwards. Thank you, Mac and Tim.
thank you. So so now let's go through the rest of this proposed changes, and then we'll go, you know, every 3 or 4, we'll go back and check.
It feels like we've talked about the right to purchase. It can be assigned to a nonprofit as income restricted. Where there is a reduction in the total units or the building is demolished and replaced by a condo building, the tenant has a right to purchase a unit in the building, including, if eligible, any income restricted units, so any IDP units.
Are any of those points changes, or these are the law?
Yes,
These
because
are
this
new.
addresses either a building that has a reduction units, or this last point is a change because it addresses where there's a reduction where their unit isn't there for them, where they can't buy their unit, but they can buy a unit. So,
Correct. And then in terms of the 90 days, are we limited to the 90 days? Can we increase that amount? I think that was Councilor Janey's question.
I think we can look at it. I'm a little shy of increasing it too much, but I think that we can. So, and maybe 120 days would be sufficient here.
Right.
But we can also look at the timing of when they get the notice. I think that may be just as important as the number of days. So we can look at that.
Okay.
Reporting, ISD, oh yes, enforcement. Current tenant has responsibility of understanding their rights and going to housing court. Proposed the condominium conversion permitting system, which I'll go in through on the next page. And ISD would be required to do an annual report.
On the 90-day piece, my recollection, but Tim and I can go back and look at this, is that Somerville actually changed that a little bit to deal with some financing issues that people might have. So, you know, if they were initially doing certain steps, but then there were some extra steps that were associated with getting the financing, I think Somerville added some good language on that, which I think is in the revised draft that we're working on.
Correct. So to look at the actual permitting and notification process, to kind of summarize the overall goal, is that the landlord would notify their tenants that they were going to seek a conversion permit. The landlord would then go to Inspectional Services Department, and the first step would be a conditional conversion permit. ISD would provide the landlord with a full understanding of both their and tenants' rights and responsibilities. The owner must provide proof tenants were notified and evidence of who is living in the building currently, and information on any residents who lived in the project over the previous 12 months. If the applicant has purchased an empty building or a partially empty building, the applicant is still responsible for providing information on the previous residents. OHS would work with the tenants to assess eligibility for enhanced notification and benefits. And then knowing whether or not a tenant was eligible for 1 year or 5 year, and whether or not the landlord had already done what was proper, ISD could release what's called a conditional conversion permit. It basically says you've done what you're supposed to do so far, and these are the steps that you must follow in order to get your final permit. Tenants throughout the notification period would be able to report any concerns and notify the city if they move, sign a purchase and sales agreement for the unit, receive relocation benefits, or face eviction proceedings. So basically, they would have a case manager at the Office of Housing Stability to do that. Then the landlord would, just prior to actually selling units, would actually come back for the full conversion permit. ISD and OHS would determine if the owner had met requirements. ISD releases the conversion permit, and then they would be able to sell the units, including any units to tenants who had secured a purchase and sales agreement. So those are the steps in that process. This is all new. As I said previously, it was all up to the tenant to kind of know their rights and responsibilities, work with GBLS, go to housing court, all those kinds of things. I think just creating this system really closes a lot of the loopholes. And because we're also doing some look back, gives us some opportunity to address some of those clear outs and a way to actually find those developers as well.
This is, I think, the biggest massive change for my colleagues, and the one that responds to the biggest issue, which was people purchasing an empty building and saying there's nothing they could do and there's no one for them to notify. And this is really putting it on, if you want to even convert the condos, landlords, you have the following steps. And you'll be checking in with the city of Boston at these times to get these permits. And I think the genius of it is you're moving it through our ISD process versus trying to change the zoning code or home rule or anything like that. It's just great. So I'm very excited about this process. So we're going to go through the final, this second half of suggestions and major changes. And I'll go in line again of order of arrival for any questions. Councillor Braden.
Thank you, Madam Chair. Going back to the eligible tenants again, is it, the 62 years for the elders? Is there any way we can bring that down to 60?
Yeah, I think, let me go back and reread the enabling law, but I think it may be possible there. 60 is usually the limit that's used for state public housing, for example.
Yeah.
62 is the HUD limit. But we should just take a look again to see if the legislature's hemmed us in. And if not, that makes a lot of sense.
Yeah. You know, one of the groups that we get calls from are actually women, you know, in that age group, like 55 to 65 years. They're being displaced, and it's very difficult for them to get relocated, and it's in the scenario that this is very often. So I really appreciate lowering that age to 60 would be, if it's possible, I think that would be great. Thank you.
Thank you. Was that all your questions for this section?
The other thing, you know, with regard to a landlord clearing a building and then passing it on to another developer to do a condo conversion, it's sort of despicable, but it happens. Is there any recourse to make that landlord who clears the building bear some responsibility for this situation? Like, is there any penalties that can be leveraged, or will this ordinance actually just severely deter that occurrence?
If I may, I think this new permitting process, Councillor Braden, allows for the city to assess daily fines up to $300 a day, and also it puts the burden now on the landlord to be proactive and informing tenants of their rights, because if they don't get a permit to convert the unit, which is really good. So this is the proposed, I think, gap filler for this to address both of your concerns.
Very good. I appreciate that.
And this is just I'm just kind of thinking out just thinking it through of a potential situation. If there was a developer who bought an empty building, they claim, or they did in fact not know that it was not properly cleared, then, and they got all these fines, would that developer sue the previous owner, or would there be, I don't know if there would be an ability to do that. I'm trying to think about what would actually happen in that situation.
If you're buying an empty building that had former tenants in it, there's a sort of a buyer beware sort of scenario there that a potential purchaser should check out all those
Right.
parameters.
Particularly since that purchaser is then going to be coming to the city agency and will have to provide that last year's worth of records about it, and if they can't assemble those records in a sufficient form, city's going to deny. So they are going to have a strong interest in, as part of any sale, getting the proof from the seller that all that stuff was clean before they do a sale.
Very good. Those are all my questions for now. Thank you, Madam Chair.
Thank you. As I believe Councillor Flynn may have stepped off, and I believe is fully supportive of the changes proposed. Next is myself. I've asked kind of my question. So Councillor Mejia, then Councillor Bach, and Councillor Asabi George.
Ooh. I would like to, I don't have any, I don't have anything right now. Do you mind if you, like, I feed off of usually other people, like for this one, do you mind if you can come back to me just in case? I don't think that right now I have a full understand. I'm still trying to process it. I'm still trying to
Not a problem. And just for you to note, at the end of this and all of our questions, I'm going to go back through and kind of note the changes so that all of us can have a final thought about it. So don't worry, we got you.
But I do, like, is this something when you're going through ISD, do abutters participate in this process? Are those conversations had here or somewhere else?
Abutters would only be involved if there was actually a real change of the property in terms of it being either on non-residential, or they're increasing the number of units, or if there's, I mean, if they're going through some kind of zoning situation, then there would be an abutter meeting.
Okay.
But there would be a hearing process as part of this.
And if these condos come in, like, let's say for instance, how would these condo conversions impact the property value of your surrounding neighbors? Do we look at how these condo conversions impact the property taxes for the people who live in the neighborhood? So let's say, for instance, I've lived in my house for 30 years and my property taxes are all right. But then you have all of these new buildings and all of these beautiful things that are happening on your block, and then everything changes. Are we looking at, is that part of this conversation? Do you guys take into consideration how these condo conversions can impact the cost of the surrounding neighbors?
No, and I'm not sure under our enabling that that's a question we could be using to determine whether or not they are converted. I'm not sure. I think that would go beyond the scope.
If I could just add to that, we're very limited in what we can do under the state's enabling authority. So for example, an owner who, instead of deciding to do condo conversions, decides to turn something into luxury apartments and is still doing it as rental, but is doing some of the bad things that we're trying to curb against here with condos, we don't have a mechanism through this to curb that. There may be other things that could be done on that, but it probably requires a much longer conversation about other enabling laws and so forth. And certainly the whole issue about gentrification and the impact on the surrounding community, so forth, should be part of that longer conversation.
Thank you for that. So much for not having any questions, huh, Edward?
That's fine. That's the point. I appreciate that. And I think you are hitting on the nail on the head, discussing indirect displacement just through gentrification, an increase in property taxes, which you and I both know there are some seniors who are income poor but housing rich, and the increase in their taxes is what's also driving a lot of people out of their homes. It's just so I think that's what you're talking about, and that's something we've mentioned before. I don't know that we can correct through this ordinance. We might have to look at other tax relief through another way.
Thank you.
Councillor Bach?
Thank you, Madam Chair. Yeah, I mean, uncharacteristically, I don't have a lot of questions here. I feel like if there's a team that I feel pretty good about, it's the Tim, Mac, Councillor Edwards team. I think has done amazing work here, and I just want to flag for everybody that, I mean, we talked about a lot of concerns back at the working session on July 27th, and we talked about what Mac alluded to, which is that the space we have here within the state enabling act is narrow, but I feel like what we're doing with this proposal really maximizes that space and does a lot to try to tackle this problem in the city. So I'm very, very much in support and very grateful for all the work on this. Thank you, Madam Chair.
Is it possible I can ask Councillor Bach a question?
Sure. Only if the chair allows it.
Is that okay, Madam Chair?
I do.
Okay. So one thing, and I think I mentioned this before you joined the call, which is that the conversion permit also may affect something where there may be a major redevelopment that's done, in which condo conversion is a part of doing major redevelopment with lots of creative financing. That might, for example, happen, let's say, in a public housing development. And so there may be questions about not creating any unintended consequences, protecting everyone, making sure all the protections are in place, but also making sure that where you're using those creative financing techniques, it can still happen. So your feedback on that as we get you a draft would be very helpful.
I would be happy to look at that, Mac. And yeah, as soon as there's legislative language, we'll definitely dig in on my side and happy to use some past experience on that front. But conceptually here, this looks great.
Okay, thanks.
Thanks.
Councillor Sabi George.
Thank you, Madam Chair.
Councillor Bach, you were done, right? Okay, Councillor Sabi George.
Thank you, Madam Chair. And no, I also appreciate sort of the clarity and the drafting and the true nature of this working session and the information that's shared and how it's been shared. So I'm very grateful for that. And I don't have any questions on this section either. Thank you.
Thank you.
And I think Councillor Janey said she had a hard stop, so she might not be with us, but just calling to make sure, see if she's here. No. Okay. So what I see are, again, just for my colleagues, the major changes. OHS having vacant properties, getting the notice, the potential change to 60 as proposed by Councillor Braden, which seems to be something, unless, you know, I think it makes sense. So vacant properties proposed by D&D and GBLS, OHS to do the notification form by D&D, OHS, or excuse me, D&D and GBLS. The rent increases staying the same. The increase in funding, as proposed right now, makes sense to me to go to $10,000 and to $15,000. Out there is a question of whether you want to add in a padded amount for folks who have to leave Boston and how that could happen. So that's out there. But I think for what I hear from my colleagues, the current increase suggestion is supported. Question is, can we go further and for moving? So then there's the 90-day. I like the suggestion of pushing that to 120 days for tenants to sign a PNS. Just now, I mean, even trying to do a refinance, I don't know if you've tried to get in line for that, and the banks are overwhelmed and it's hard. And it's hard right now. So a little more time would be helpful. Reduction in total unit demolished and replaced. For condo, the tenant has a right to purchase in the building, even if their particular unit is gone. Great. Condo conversion permitting system. that whole entire system would be added and basically puts the onus on the landlord. Like any other move that they want to make for their building, this is another one that they would have to go before ISD and make sure they comply with the law, and they would be fined if they're not. And it would certainly fill in the gap for the building clear out excuse that too many of them got away with beforehand. Right now, as it's written, it would apply only to 4 units, but technically it seems to be open a little bit more. And Tim and I were discussing if we wanted that to be a different notification, it might need to be a different ordinance.
Right, an ordinance that would specifically call out what kind of notification process there would be for
Condos.
smaller, 3 units and smaller, yes.
Okay. That
I mean, it
notification.
can be drafted at the same time, you know, obviously.
We could draft it at the same time.
It would
but
just be a
not-
separate, it would be a separate vote. That would be what it would be. Yeah.
So a separate small notice, which I don't know if you had any, this is to GBLS and to D&D, does that make sense? I mean, I know we're notifying them that they really don't have a lot of recourse, but we are still notifying them that they should contact OHS, GBLS or something.
I think it's fine. I think we'd need to use kind of the same formatting or framework that's being used on the Notification Act, but I agree it should be separate from that.
Yeah.
Oh.
Yeah. Yeah.
All right, so those are the major summaries as I recall and as I see. And I'm happy with what's proposed right now. And plus at least the 60 years and the 120 days. I understand the increase in the funding beyond the 10 and 15,000 might be need to check to see if that relocation distance is a qualifier.
Is permissible, yeah.
Is a qualifier. And then the separate ordinance for the 2 to 3. So for my colleagues, you know, just to let you know, this is something that is just, it is a massive, this is a huge deal to get all of these things and to get them done. And so my goal would be to get the language tightened up on this as soon as possible on the things we can agree on, right? And the things that we, I don't know that there's disagreement. It's just a matter of if we can go as far as we'd like, but at least get this done. And so that we could pass it. I don't know if we can get it done by the 21st, a week, less than a week from now, but at least Tim says no, but you don't know me, Tim. You don't know me. You don't know my. No, I'm just kidding. But
I have to wrangle the legal department too. It's not just me. So
that's fair. So we will definitely have something passed, though. I can see in November, next month. I mean, we only have 2 weeks in December, so we're getting it done this year.
yes, we are getting it done this year. We are
And it
getting
would
it
be
done this
for
year.
a five-year extension.
Yeah. Yeah.
And there were some fairly small other changes in this. For example, we even talked about this last year about there were little glitches. There was a bad housing court decision. We were going to clean up some of the language on things like just cause, things like that. That's in this as well.
Excellent. Yep. So to my colleagues, I'm going to just throw it out there if you want to raise your blue hand for concluding remarks, but I think we've done the work. We're just going to get now to writing it out. So there we go. 2 hands, blue hands in the air. Councillor Braden and then Councillor Mejia.
I just want to thank everyone for their work on this. This is I agree, it's a hugely important issue, and this is a great remedy that we're working on, and hopefully we can get it done nice and quickly. We've a lot, Councillor Edwards, there's a lot of ducks lined up here, so we get it done quickly. Thank you so much.
Thank you. Councillor Mejia.
Yeah, so I also wanted to just give you, Councillor Edwards, a shout out, and Tim and Mac, both of y'all too, for your work on this. This is really exciting. And also I have to say it's very educational. So I think for folks who don't know how things get done, just even being part of this process helps people understand how the city is working with them and for them, right? I think that this getting this approved could really help a lot of people. So I'm glad that I was able to witness it and happy to support it. So thank you for your hard work on this.
Thank you. All right, anybody else? Okay, well, thank you guys so much. We'll get working on this language to get it done this year.
Thank you.
Thank you.
All right.